Hello, Christie Arkovich from Tampa, Florida. The topic I'd like to talk about today is how to avoid bankruptcy. You know, you don't really get up in the morning and say, I want to file bankruptcy today. It's just not something that happens. Um, but there's ways that you can try to avoid bankruptcy. I mean, sure, not incurring debt, making more money, all that, of course. But the things I'm talking about are really not letting something go too far. The biggest reason that I think that we have to file bankruptcy for someone is that there's already a judgment, there's already garnishment, and there's really nothing else we can do but file bankruptcy to end those things. For instance, when you're first served with a lawsuit, usually you have 20 days to respond, at least here in Florida. And sometimes people let that time go. They just are busy. They don't have any money to fight the case. They don't think they have any money to hire an attorney. I mean, most of us work on installment fees where you don't have to pay all at one time, all up front. But nevertheless, folks don't realize that. And so they let the case default and a judgment's entered against them. Well, the problem is then you've lost. You might have had a number of good defenses, statute of limitations. Maybe the payment history wasn't complete, so they really can't prove how much was due, how much the judgment should be for. That's a requirement, by the way. Maybe there's some lost documentation. That happens more than you think. You probably heard about it on the internet a lot. So you got to fight the judgment. You got to defend the case. If you don't, the judgment lasts 20 years and they've already won the case and you can't raise any of these defenses. Also, once they have a judgment, they can garnish your wages. Now, a garnishment can take 25%, a state garnishment can take 25% of your wages. Most people can't live on what's left over. And so we'll hear from clients after a garnishment has already started. Well, if it's early enough, that might be in enough time if they have an exemption to garnishment, head of household or something where we can basically stop the garnishment. But if there's no exemption, then negotiating the debt at that point is practically impossible. The creditor's already won. They have a judgment. There's no defenses hardly to it, except for maybe improper service. And now they're getting paid. They have a employer that's mandatorily sending 25% every single paycheck to that creditor. No one quits their job to avoid that. I mean, you could, but most people don't do that. And so if you wait till it's garnishment and you wait till they have a judgment, you've pretty much walked yourself into bankruptcy court, because a bankruptcy at that time can eliminate the debt. So that's good. I mean, we can get rid of the judgment, we can get rid of the garnishment. It's immediate, it's wonderful, it fixes the problem. But if your goal is to avoid bankruptcy, then trying to make sure they don't get the judgment and make sure they don't get to garnishment is probably your best bet to avoid a garnishment. So thank you very much for listening. And keep in mind that we have a lot of free resources on our website about garnishment, foreclosure, different types of bankruptcies, and most importantly, a lot about student loans. And we have another series about all the different things during COVID that we're expecting to see from the Biden administration, some things we've already seen, some things that we're going to see probably over the summer. So stay tuned and hope it's been helpful for you. Thank you.